What's up, bosses? Welcome back to my channel, and today we're going to talk about a very important topic, which is the closing process and the changes on real estate market and laws and regulations during this period of time that we are living right now, which is unprecedented. But before we start it, as everybody's doing right now, we are working mostly from home, and I have a very cute little American Bulldog, which is in love with my downstairs neighbor's dog, and he hates my next door neighbor's dog. So if one of those shows, he will bark, and I can do anything. Just remember how cute he is, because I'm going to put a picture of him right now. And to talk about those subjects with us, I have here with me Cristina Ortiz. She is a lawyer, a lawyer, if I can say that, and I will let her talk better about what she does and how important that is for people that are buying or selling properties here in South Florida. Cristina, please introduce yourself and let us know how can you help everyone that are doing real estate transaction at this moment.
I can definitely help. Daniel, thank you. Like you said, I own a title company, and actually I'm a real estate lawyer who happens to own a title company. So you said it right, a closing lawyer. That's synonymous. It's perfect.
Perfect.
Yeah, I'm offering a lot of help to my clients, especially, you and I are both real estate professionals. You know, the ones that are being affected are the ones that were already in contract before the pandemic and all these social standards changed. And there's a lot of stuff changing that affects their current contract. I think those are the ones that are being the most affected, and therefore need the most help and guidance right now. The ones that are getting into contract, I actually think it's a great time to get into contract because of the opportunities. We just have to navigate through some of the, I guess, the precautions that you have to take, because we could talk about it later, but I have a certain opinion about what's happening with the addendums that are affecting the contracts due to COVID. There's a standard COVID addendum that I'm sure you've reviewed. So those are the type of things that I'm guiding my clients and realtors on a lot these days.
Okay, so let's start with I think, a very important question and a basic one. Every time you enter a real estate transaction contract, if you use the Florida Bar and Realtor Association standard, you have inspection period. Sorry about that. You have an inspection period, which normally is 30 days, and during that period you can walk away from your contract most of the time without any problems. The problems start when you went through that period, that 30 days or whatever period, and now you need to do a hard deposit and move to the closing process. Let's say the people that ended the inspection period, and now they already have a hard deposit. Can they get away from the contract because of this scenario at this moment?
That's a question that I'm answering every day. So you're right. The inspection period is the ideal time to do all of your research on the property. Not only should you be inspecting the physical part of the property and its condition, but I always urge my clients to take on the extra expense of doing a quick lien search, a title search, because there you could really see what's recorded against the property. So that's in a normal transaction, right? Your inspection period is the time for you to do all that due diligence. And if you find something that you either can't resolve with the seller or something that makes you want to back out as a buyer, you can with your full refund. That's within the traditional inspection period. What we're running into now is that we are not only past the inspection period, but we're also past the point of when there's a loan involved. If the buyer's already been conditionally approved, now we're even past that loan commitment date, that loan approval date. So at that point, the buyer doesn't have much relief, okay? What is being afforded now, and it depends on whether you're on the seller side or on the buyer side. The COVID discussions and COVID talks and the addendum are in place to not penalize buyers that are not able to perform their obligations due to reasons out of their control, okay? That's where force majeure comes in. It's that clause in every contract, that standard language that nobody even pays attention to unless there's a hurricane, right, here in Miami. Actually, the Florida Real Estate Commission's general counsel, I've been following it a lot because they're bringing clarity, or not so much clarity, as to how this applies. So I'm going to provide some real life examples because I think that's the best way to learn and for me to share what's going on.
Yeah.
So what's happening is the week of closing, we're already a couple of days before closing. The lender will all of a sudden either completely deny after already issuing the approval. Now they've denied the buyer. Or they'll say, oh, well, we have conditions now. And guess what? What are one of the conditions? One of the conditions is to re-verify your income and re-verify your employment status up until the day of closing. So the lender is, kind of covering themselves by these conditions now, saying, well, we always have this condition of employment, so up until the day of closing. So how I interpret that is, well, in reality, do we really even have a clear to close or approval until the day of closing? And is that even really fair for the seller? So it really is a double-edged sword. I understand that the precautions in place due to COVID are to not penalize the buyers. But I see a lot of sellers saying, hey, why did we even get into a contract? Isn't a contract binding? And nowhere on a contract does it say that, you purchasing a house relies on your employment. Yes, under that, you have the qualification, that you have to get approved for the loan and you have to get your loan. But I'm running into a lot of those questions. So what'll happen is that the buyer, what I'm telling my buyers is, if you can show proof that the sole and only reason that you were denied for your loan was because you got laid off, and you got laid off because of COVID, then you have a chance to get your deposit back. This is not a blanket law, though. You still have to go to mediation. There's no, when everyone is throwing around the word unprecedented, right?
Yes.
Unprecedented means that it truly is unprecedented. There is no precedence. There's no legal precedence that we can open up a law book to and say, this is what happens when there's a pandemic and people lose their jobs. There's no clear black and white law. So the contract also calls for you going to mediation. And at mediation, the buyer is going to have to show that, but for COVID, they would have been able to close on their contract. Okay.
But it's still the buyer needs to, because I'm from another country. So my vision of the legal system here was very different than whatever it is. Even though I have the right, I need to fight and pay for it. So as you told, as you said, it's not because we have the pandemic, we have this, we have that, you have the right that you're just going to walk away and the seller is going to give you a deposit back. You need to fight for it. And
right, because that's what's fair, right?
Exactly.
I always, on a human level, that's what's fair. But think about it. All, parties have incurred costs.
Yeah.
The seller has lost the opportunity. You're a listing agent as well. The seller has now lost 40 days of an opportunity to sell it to someone else. The value could have also dropped because now the seller is scared of, oh, am I going to sell this house now if I relist it for the same? There's costs, okay? And this is the law. This is the law aspect, and then there's a human aspect. I get, for example, the lender's perspective. Why am I going to give a $350,000 loan to someone who just lost their job?
Yeah.
Practically speaking, that doesn't make sense, right? Of course. So, you have the lender's perspective, the buyer's perspective, and the seller's perspective. I understand all that. Because all of that is so, multi-dimensional, you have to go to a mediation and have a mediator, a neutral party, say what's fair. Okay, in this circumstance, it's fair for the buyer to get their deposit back. And the American justice system sometimes isn't fair. It sometimes leans to the party that has the deeper pockets and can pay for an attorney to go to mediation.
Yeah.
And so, unfortunately, another, how I try to advise my clients is from a common sense perspective as well. I just did it this morning. I said, how much is your deposit? $5,000. That's a normal, on a residence, that could be a normal deposit amount. Well, sometimes you're going to spend $2,500, $3,000 on the attorney fees to prepare and get ready for mediation. I mean, you could ask for your attorney's fees back if you win, But those are all risks that, unfortunately, the buyer has to take. We're all taking risks. The lender's taking a risk, the buyer's taking a risk and putting down the deposit and going to mediation, and the seller took a risk by signing a contract with the potential that the buyer won't qualify for the loan. So that's in a case where there's a loan. With the cash transactions, there's no problem with those. Those are
just before we move to the loan, to the cash transactions, on the loan also, on the loan transactions also, usually there is a clause or an addendum that the purchase is subjected to getting a loan. So even if you pass the inspection period, you pass the inspection period, until the inspection period you had your loan approved, but as you said, the bank can deny the loan at day of closing. So in that case, does it make it easier for the buyer to get their deposit back because there was a condition for the purchase to have a loan?
It would be on their, it would give them leverage because, for example, that's what I said earlier in this conversation is what I've advised my buyers is to show that they got denied, that they were not approved because of their employment or income situation. Okay. If you look at the language, so the FAR, the Florida Realtors contract, the as is, it changed back in 2017. Before 2017, it was that the buyer had to show a commitment, an actual loan commitment, and the language changed to just being approved. Now, was it conditionally approved? There's conditional approvals by lenders. There's approvals, they're somewhat vague. And then if you've had that experience where you've actually now in this situation in these times asked a lender for a denial letter, they're sometimes reluctant to issue an official denial letter to your buyer. So your buyer doesn't have an official denial letter at times up until, and we have been getting in my closings, I have had a few denials, but it's been, days before the closing. And it's a case by case situation, Daniel, because for example, I had one last week where we actually did get a denial letter on the loan based on loss of his employment. He got laid off mid-transaction because of COVID. But guess what? He knew he was unemployed as of March 17th.
Okay, so then there's a problem.
And he didn't notify, the buyer did not notify the lender, did not notify his attorney, and and he kept it going. We even signed an extension because he said he needed more time for the loan approval, and the whole time he knew he was unemployed. So that to me is bad faith, and I advised my client, who's the seller, I said, do not sign the release of deposit and cancellation because this person knew as of March 17th. This isn't a force majeure, act of God situation. It wasn't but for this, he would have closed. So especially when he knew, that's for me is bad faith intent. So
yeah, but even though the language is not something that it's under the buyer control, because you said needs to have a commitment. And what is a commitment? The old contract. Well, it doesn't change much because this is the example that I'm going to give is not based on residential transaction, but I have a construction, I have a multifamily project that we are renovating. I had the loan approved. I had the commitment letter sent and the deposit for the commitment done to the bank. And on a Friday, everything was fine. And on Monday, the bank said, Daniel, we are shutting down, putting on hold for 45 days, and we are not releasing anything. So I was ready to close. I had a commitment letter. I had an approval. I paid the commitment letter because the banks already asked there for their costs and appraisal and everything. And now I have two options. Either I wait for this bank for 45 days to see what they're going to do, or I go to another one and just lose the commitment that I have. So what is a commitment on real or approval on real estate law? Is just a letter? Because
so in this
how can the banks be held liable also? Because one day he approves and the other day the banks just say bye.
So two things. So based on what you're telling me in your commercial construction transaction, I would say, and I would argue if I was representing the buyer, that the buyer complied with everything that they needed to. Okay. And therefore they're not in default because it was the lender who, and it is out of their control. It was the lender who said, okay, we're holding all funding for 45 days. Okay. So if I was representing the buyer, I would argue that the buyer is not in default. Now, this has been up for debate for a little while, and now there's a spotlight on it, on the whole loan approval for residential. You know, what is a loan approval? Okay. Yeah. And that's the job of the title company or the real estate lawyer who is representing the buyer to really say, okay, well, what type of approval do we really have here? Because when everything is going smoothly and the lender's mortgage originator sends out an email that says, hey, you've been conditionally approved. Well, we all, especially now, need to say, well, what are those conditions? Because what you're saying is, we've approved you, but we are withholding our power to deny you for whatever reason we want later. And now what I'm doing is I'm tightening that up and I'm saying, well, do we really have an approval here? And if not, we're going to need an extension on getting this approval to protect the buyer, of course, and the seller at the end of the day, but both parties. So it is it is vague. That clause right now in the real estate contract is a little vague, and it's the job, in my opinion, of the lawyer and the title company involved to really clarify that for each transaction and for each party.
Move forward. And in the case of cash transactions, how is that being taken? Because it's a cash transaction, you have on the buyer side, you have one leverage less because you don't have that condition to get approved by a bank to purchase the house. You passed the inspection period, you have your hard deposit, but all of a sudden everything happens like is happening right now, and you have second thoughts on the purchase. What should you do?
Now the buyer has fear, for example. That's the only thing at this point that would be holding a cash buyer back, because, and that's a valid feeling. But again, you signed a contract, it's a cash transaction, you're past the inspection period, okay? And at that point, if you're a cash buyer, you say, you know what, I don't want to go through with this transaction, I'm going to cancel. That's something else that I think people forget, is you can cancel the contract, no problem. You don't have to go through with the transaction, really. But yes, you will lose your deposit if there is no legal basis for you to get it back. And if you're a cash purchaser, you're past the inspection period, there's no loan contingency, there's no other contingency, and we're a week away from closing, and we could close, especially because you're a cash purchaser and you could do everything virtual now. There's no, unfortunately, I don't foresee that buyer would have a reason to release their escrow funds back. They could cancel.
Yeah. And I'm hearing a lot of people that are deliberate canceling the contract, not moving forward, because in their mind the real estate will decrease in value, that what he can buy in 1 month from now or 40 days from now, it's enough to get the contract back. And yeah, for an investor, for example, yeah, on a 5 to 10% deposit, I believe that could be a strategy. But the investor or the buyer needs to know that if he put a 10% deposit, the real estate to be worth, it needs to come down more than 10%. So much more than 10%. The first 10% that the real estate that he wants to buy, the property he wants to buy, goes down, he's just equalizing what he lost. He's not making money on 10%. So his expectation is that the market will go under 10%, which I don't believe in most of the cases, because different from 2008, the banks are avoiding foreclosure as the most they can because they know what the process is. They have a lot of costs foreclosuring people, and then they need to put the property back on the market. And what happened in 2008 was the banks had so much property that when they put on the market, the value went down, and that's what they don't want to do at this moment. So in terms of foreclosure, what has changed or what you're seeing on the closing table or in the real estate market? Do you see the banks being more flexible to not foreclose their clients? What they're doing to navigate through this in the benefit or not of a real estate investor or buyer?
Well, Daniel, actually, I started my career in foreclosure defense. Back in 2008, that's when I graduated law school. And I went right into the foreclosure and bankruptcy world and short sales. I was actually practicing real estate law and didn't even know it at the time. I wasn't familiar yet that a short sale was indeed a closing. But that was one of the loss mitigation options for our clients. And I had, as a young attorney, I had over 500 clients as an associate at a firm. We had lines out the door with people lining up for foreclosure and bankruptcy defense. At that time, it was a question of over leveraging. People bought multiple properties way past what they could afford, and there were no standards or very low standards on lending, right?
And no down payments.
Yeah, exactly, and no income verification. It's too early for me to predict that what kind of foreclosure era is coming, but foreclosures will be coming. And the reason why, sorry, I lost you. Okay. Mm-hmm. The reason why is because what's happening now is that there's a moratorium in place. The courts, okay, and the county has ordered the courts to not move forward with foreclosure actions and foreclosure hearings, for example. That is not stopping a bank's right to foreclose on the property that gave them the security in the first place to give you a loan. Yeah. Eventually, they're going to be able to foreclose on you. I mean, the moratorium means a temporary suspension. Forbearance means temporary suspension. It's not forgiveness. For example, this morning I was on a call with Wells Fargo, which is a huge lender, and they're just talking about waiving late fees during this time on your mortgage payment. So as far as foreclosure is concerned, they're coming. It's just that they're on hold. So if you're a borrower and you truly cannot make your mortgage payments, you have time. But that's all you have right now. So communication with your lender is key in discussing what options you have so that you can take advantage of those options. But at the end of the day, and let's just call it, a year from now, at some point I do foresee that, even commercial landlords, right? Yeah, residential commercial landlords who aren't getting paid rent are going to, when this moratorium is lifted, can pursue their evictions, because this is look at the common sense approach, right? Yeah. I own a property. I'm going to buy an investment property so I could earn an income. That's part of my livelihood.
Yeah, of course. Yeah.
So the lenders are as well. I know nobody likes the big bad banks, but again, I go back to contracts. And by the way, I'm not defending banks or anything. I just have so much experience with foreclosures that I was in court, for years, defending clients against banks. And it all came down to, did you sign this promissory note? Did you sign this mortgage? And have you defaulted on your payments? Okay, the answers to those questions are all yes. So the bank, if they could show that they own the note and you didn't pay, and you signed a mortgage that says if you don't make your mortgage payments, I could take your property to pay back the loan that you promised to pay that you now can't. That's what a foreclosure is. Yeah. So that's the big picture of a foreclosure.
What I'm seeing by talking to lenders is that they are being flexible in the sense of, okay, you didn't pay 1, 2, or 3 months because you lost your job, because you lost your income. We are going to take those payments that you didn't make, and we are going to put it in the back of your contract, and we are going to extend your contract. So, as you said, you gain time. And gain time and winning time at this moment is essential for the buyer. The bank yeah.
So you're going down to forbearance, okay? Foreclosure already, it comes in, down the road when you are in trouble and you haven't made your payments in several months. So what you're talking about is forbearance. So let's just say I'm a borrower, and in good faith, I've been making my payments, but due to COVID or due to some other unforeseen hardship, I can't make my payments. Well, you can apply for a forbearance. Something I want to, and I'm going to be actually writing a blog about this, kind of like a Mythbusters. Just because COVID is going around right now and it's all over the news about the CARES Act, you just not paying your mortgage doesn't automatically give you the forbearance. You have to apply for it. Your servicer and your lender has, online tools as far as also, in addition to the phone, which I would never recommend any client to call the lender, but online they do have resources and pages and links for you to apply for the forbearance, which you have to do. You have to gather your financials and you have to explain what your hardship is. Lenders are being more forgiving and more flexible in the qualifications for forbearance. And one of the many options, and one of the options is what you're talking about, is putting the unpaid amount, which right now it's around 90 days. Each lender is giving you 3 months worth of forbearance. You don't have to make your mortgage payments for 3 months. They are putting it on the back of the loan. So now they're extending the time that you're going to have to pay back the loan. They're also allowing repayment plans. So for example, if in 6 months you're back to somewhat normal, you could pay a little extra over your normal mortgage payment to get into some kind of repayment plan. And then there's also an extended modification. It's like applying for a loan modification all over again. So those are three options. Some other good news that I have is that lenders are extending it. If at the end of the 90 days you need more time, they are allowing you to request that as well. So those are all options that are available. I can't predict, like borrower A is going to get 180 days based on these factors, and borrower B is going to get 90 days based on these factors. We don't know, and unfortunately, the unfortunate part that I see is that a human being is going to have the hat of an underwriter, and they're going to be looking at your financials and what your hardship is, and they're going to be making the judgment of, okay, you get extra time, or no, we can extend your hardship beyond 90 days.
Cristina, before we run out of time here, in 1 minute, tell what's the best practice for the buyers at this moment to just take care of themselves during this closing process.
Okay, let's talk on a human level. If I'm a buyer and I'm going to be getting a loan, right? When I get pre-approved, I need to have a better, clearer picture of what was the basis for getting approved. I could share an example, which is, I just got into contract, or one of my clients just got into contract, and I had a conversation with the originator who qualified. I said, let's just say their income is cut in half between now and the closing. What is the safeguard here? And the originator said, per my review, this person has enough assets that if their income is cut, we'd still be able to put them into some kind of loan. That's one thing. Another thing is, and I'm just talking legally here, the buyer and the buyer's realtor need to take advantage of the COVID-19 addendum, which that last paragraph of that addendum says that if I don't get approved by a loan, or I lose my job, or I lose my income, I can cancel the contract and get my deposit back. I mean, that is the most favorable language for a buyer right now. So that's what I would do. And then as far as being on the seller side, right now it's a little tough and it seems unfair, but maybe ask for a larger deposit, or have a better, have a clear communication with the buyer's lender, have it as an open communication to know what's going on, so that you're not hit with a surprise a week before closing about your buyer. Those are the type of safeguards that I would have in place right now. Another thing that I'm urging all of my realtors to do is, if you have a pending transaction right now and you have a client out of town or out of the country, set up some time and get a power of attorney in place, so that there's no hiccups as to availability for signing, or I don't have access to a computer, I don't have access to a remote online notary. Get a power of attorney in place. That's what I did for my clients about 2 to 3 weeks ago, and it worked. I had 2 closings go through last week due to the power of attorneys that I put in place.
Perfect. Cristina, thank you very much for those insights. It's a very unprecedented and different moment for everybody. It's a great moment to learn a lot and to have great opportunities and do great deals also. Thank you very much.
As updates come along too, I just want to share, as updates come along regarding some of those loan questions that we had, I'm going to share with you, Daniel, so you can share with your viewers and your audience, okay?
Okay, thank you very much.